Well, hello everyone, and welcome to Uncivil Law. I hope you're well, and I suppose we will do a episode of Kraken Watch 2020. So when we last left the action, Sidney Powell was filing lawsuits releasing the Kraken, and we have a decision from Michigan in Kraken Watch. So we're going to skim this and speed read this because I've heard it's pretty good and really just kind of rakes Sidney Powell the coals and loses on every possible issue. And I'd like to remind people once again, because I don't know why people keep forgetting this, that I'm a conservative and Republican, and yet I'm also a conservative legal guy. And so that comes with certain sets of principles, among which is, rule of law and following rules and procedure and all the rest of it. So if you get your ass handed to you in court, because you're a joke, I get to make fun of you no matter which party you're in. So let's make fun of Sidney Powell. Because she keeps saying, here's a Kraken, there's a Kraken, everywhere, a Kraken. And I'm not seeing any Krakens. Some Karens occasionally, but less on the Krakens. All right, so let's read whatever this is from the Eastern District of, the Eastern District of Michigan, the Southern Division. The Southern Division of the Eastern District. That's confusing, but whatever. Before the Honorable Linda R. Parker. Exciting. All right. Let's get started without this. The right to vote is among the most sacred rights of our democracy and in turn uniquely defines us as Americans. I'm not so sure about that. Lots of people have the right to vote. I'm not sure it uniquely defines us as Americans, but okay. The struggle to achieve the right to vote is one that has been both hard fought and cherished throughout this country's history. Local, state, and federal elections give voice to this right through the ballot. And elections that count each vote celebrate and secure this cherished right. These principles are the bedrock of American democracy and widely revered as being woven into the fabric of the country. In Michigan, more than 5.5 million citizens exercised the franchise either in person or by absentee ballots during the 2020 election. Those votes were counted and, as of November the 23rd, 2020, certified. The governor also sent the slate of presidential lectures to the Archivist of the United States to confirm the votes of the successful candidate. Well, also the Electoral College will be meeting tomorrow, as a matter of fact. So, no, apologies. The safe harbor date is tomorrow. The Electoral College meets next Monday. But yeah, it's coming up soon enough. Against this backdrop, plaintiff filed this lawsuit bringing forth claims of widespread voter irregularities and fraud in the processing and tabulation of votes and absentee ballots. They seek relief that is stunning in scope and breathtaking in reach. This is always a good tip. This is one of the things, there's an entire semester on this in law school, entire courses you can take on this just called remedies, right? So the whole thing about what do you do about it is a whole thing unto itself. So you can analyze law at a lot of different points of analysis. But one of the points of analysis you can do is what do we do about it in the end? What is the ultimate thing we can do? And if there's nothing you can do about it, then it's non-judiciable. But if there is something you can do about it, then it's judiciable. But the more you ask for, the harder it's going to be. And if you're trying to throw out votes, prevent certification, can get them to do any sort of legal declaration along those lines, you're going to need quite the Kraken indeed. You're going to need something Kraken-like to be able to get the kind of reliefs that you're talking about. And I think we all kind of want that to be true in our own lives, don't we? I mean, if someone wants something from you in court, you want them to prove it. And presumably, the more they want, the more proof you want. The more they want to be sure. So I don't know why we would treat a presidential campaign or an election any different than we would treat anything else that happens in our day-to-day lives. Would you want your vote decertified or your vote not counted? If you don't, then everyone else's vote should be counted, right? And if we're going to throw out your vote, we want a lot of proof or a lot of evidence. If we're going to throw out everyone's vote, we need more evidence, more proof, right? So just trying to be somewhat consistent is helpful. And when you're asking for a lot, you need a lot. So yes, if granted, the relief would disenfranchise the votes of more than 5.5 million Michigan citizens who, with dignity, hope, and promise of voice, participated in the 2020 election. This court declines to grant plaintiffs this relief. Yeah, you're asking for a lot. You're asking for a lot. We're going to need a lot. And if we don't get a lot, we're not going to do that. In the weeks leading up to and on November the 3rd of 2020, a record 5.5 million Michiganders voted in the presidential election. Many of these votes were cast by absentee ballot. This was due in part to the coronavirus pandemic and a ballot measure that Michigan voters passed in 2018 allowing for no reason absentee balloting. Okay. When the polls closed and the poll votes were counted, former Vice President Joe Biden had secured over 150,000 more votes than Donald Trump in Michigan. Michigan law requires the Michigan State Board of Canvassers to canvass results of the election by November the 23rd. The state did so by a 3-0 vote, certifying the results for the electors of president and vice president, among other offices. The same day, the governor signed certificates of ascertainment for the slate of electors for Vice President Biden and Senator Kamala Harris. Those certificates were transmitted to and received by the Archivist of the United States. Federal law provides that if the election results are contested in any state, and if the state prior to election day has enacted procedures to decide controversies or contests over elections or electoral votes, and if these procedures have been applied, and the decisions are made at least 6 days prior to the electors' meeting, the decisions are considered conclusive and will apply, counting the electoral votes. This is the safe harbor date. In my view, this is a slight overstatement of what the safe harbor date is. I wouldn't state it in quite these strong terms, but, whatever. Close enough. It's a little strong in my taste, but it's fine. This safe harbor date falls on December the 8th, which is tomorrow. Under the federal statutory times table for presidential election, the Electoral College must meet on the first Monday after the second Wednesday, which is December 14th of this year. So they meet tomorrow. Apologize, the safe harbor date is tomorrow. I keep making that mistake. The safe harbor date is tomorrow. The Electoral College meets the following Monday, so they meet a week from today. And then, of course, the electoral votes are then sent to Congress that counts them on January the 6th. The January the 6th date, in case you're wondering, is set by law. So it's always January 6th every year. But the date the Electoral College meets is the first Monday after the second Wednesday because, I don't know, reasons. Alleging widespread fraud in distribution, counting, and collection and counting of ballots, as well as violations of state law as to certain election challenges and manipulation of ballots through corrupt election machines and software. The plaintiffs filed this lawsuit at 11:48 p.m. on November 25th, the eve of the Thanksgiving holiday. Plaintiffs are registered Michigan voters and nominees to the Republican Party to be presidential electors, so they would be electors if the Republicans had won. Each party picks its own slate of electors. They are suing Governor Whitmer and the Secretary of State in their official capacity as well as the Board of Governors. So they say, we have been harmed. We have been harmed by our vote not being counted or whatever, or our inability to act as electors. Okay. On November the 29th, a Sunday, plaintiffs filed the first amended complaint and motion to seal. In the first amended complaint, they alleged for 3 claims. Violation of the Election and Electors Clause, good luck with that. Violation of the 14th Amendment, good luck with that. Denial of the 14th Amendment due process, good luck with that. None of these seem very promising off the top of my head. It's like I can just run the lawsuit in the back of my head. It's not a great sign when I feel like based on the causes of action, I can run a simulation of the entire lawsuit in my head. That's not super encouraging for the complexity of the lawsuit. It's like, based on the causes of action alone, I can run an entire simulation of the entire lawsuit. I was like, I know what you're arguing, and I know what the argument is. I know what the response is, and the response, and I know how it all comes out. Not super encouraging when I can do it, in the space of a half a second. But fortunately, this is not the first time we've seen these complaints, nor the first time I've had to think about it. So fortunately, I'm able to do it fairly quick. But the fact I'm able to do it super quick is not super encouraging for these causes of action. Yeah. By December the 1st, motions to intervene had been filed in the city of Detroit and the Democrat National Committee and Michigan Democratic Party. On that date, the court aired a briefing schedule with respect to the motions. Plaintiffs had not yet served the defendants with their pleadings or emergency motions. Well, that's a bit hard because service would be hard. I mean, you'd have to do it by courier. But, we do it as best we can at this point. On December the 1st, the court also entered a text-only order to hasten the action to bring the defense into this case and enable the court to address the motion. Later that same day, after plaintiffs filed certificates of service and the amended complaints on the defendant, the court entered a briefing schedule, requiring response briefs by 8 p.m. on the 2nd and reply briefs on the 3rd. We're moving very, very fast. Yeah, we want an entire reply brief in 24 hours. That's doable. That's definitely doable. But it would be a very long day for me if I had to do that. If I had to write an entire reply brief, if they filed at 8 and I have to file a reply on 8 the next day, that's going to be a long 24 hours. It's doable, but that would not be fun. On December the 2nd, the court granted motions to intervene. Response and reply briefs were thereafter filed. Amicus curiae subsequently moved and granted leave to file support. Supplemental briefing was filed. Everyone is filing briefs. You get a brief, you get a brief, you get a brief. Everyone gets a brief. Fun. In light of the limited time allotted, which the plaintiffs assert must be granted in advance of the safe harbor date, the court has disposed of oral argument pursuant to rules. So we have gotten rid of the oral argument. We're just going to do it on the papers, which is an option. Courts do that sometimes. Standard of review. A preliminary injunction is an extraordinary remedy that might be awarded upon clear showing that they're entitled to relief. Yeah, as is true in many things, the legal standard is going to be the killer. So all these people are asking for injunctions, right? So you're asking for an injunction either to do something or to stop doing something. So an injunction is to enjoin, and is in either in order to stop doing something or to do something. And the 4-part standard is very well established in law, and they're equitable remedies, and they're considered extraordinary in a normal case. They're considered extraordinary in a normal case. And so it's like if we're going to do an injunction here, it's got to be pretty good. Is it pretty good? No, probably not. So the injunction standard is, as always, going to be a killer. This is the thing that you have to pay attention to. The legal standards are actually important. The plaintiff bears the burden of demonstrating the entitlement to presumptive relief. Such relief will only be granted where movement carries his or her burden proving the circumstances clearly demand it. Evidence that goes beyond unverified allegations of pleadings and motion papers must be presented to support or oppose a motion for preliminary injunction. And then we come up with a 4-part standard, which you have seen many, 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 many times if you've watched this channel. Different courts phrase it slightly differently. The elements are written slightly differently, dependent from case to case, but this is the same 4-part standard for preliminary injunctions everywhere. Sometimes the verbiage is a little bit different, but this is the 4-part standard everywhere. Here are the 4-part standards. Whether the movement has a strong likelihood of success, whether the movement would suffer irreparable harm, whether the injunction would cause harm to others, whether the public interest would be served. Okay, so let's rephrase that. Can you win? Is this going to hurt you in a way that you can't be made better? Does it hurt others? And does it help the public? Citing this case, citing that case, it's basically the same part everywhere. How likely are you to win? How much will you be hurt? How much will it hurt others? Is it in the public interest? At a preliminary stage, a plaintiff must show more than mere possibility of success, but need not prove his case. So exactly what that means is, it's not 51%. We know that. So it's not 51%, and it's not like just the most plausible. It has to be a little bit more than just plausible. So what exactly does that mean on a percentage? I don't know. Let's say 20%. That's something along that ballpark, right? Proof required for the plaintiff to obtain preliminary injunction is much more stringent than proof to survive a summary judgment. Summary judgment, if you're doing a summary judgment, it's because Well, in a summary judgment case, all the facts are not disputed, or the facts that aren't disputed are so ridiculous that we get to ignore them. Either way, you just lose as a matter of law. So yeah, if you lose as a matter of law, you're there. So you need more than that. So yeah, 20% is about right. You don't need that much to survive a motion for summary judgment. To survive a motion for summary judgment, I mean, technically speaking, you just need 1%. But a summary judgment will be granted as long as there's no facts in dispute. And then it's just a matter of who wins at that point. So, but yeah. Anyways, the court begins with discussion of those questions that go to matters of subject matter jurisdiction or which counsel against reaching the merits. Okay, do we have subject matter or should we actually do this at all? Right? So some sort of abstention doctrine, maybe. Courts have many, many abstention doctrines. The word abstention means exactly what you think it would mean, to abstain. And the federal courts sometimes say, you know what, even though we could do this, we're just not gonna. There are many different abstention doctrines. So can we do this? Should we do this? Okay. While the court finds any of these issues alone indicate it should be in mind, it decides to address them thoroughly. So even though any of them would be enough, let's discuss them all just to prove that you're a bunch of jackasses. All right, let's discuss the 11th Amendment. So the 11th Amendment the 11th Amendment in its words prevents citizens of one state from suing another state in federal court. So citizens of one state can't sue another state in federal court. As a matter of interpretation, it also prevents citizens of the same state from suing their own state in federal court unless there is a specific federal law that allows for it. And there are many specific laws that allow for it, 1983 perhaps being the one that comes up most obvious on this channel. But that's the 11th Amendment. So we have the 11th Amendment, which says, the judicial power of the United States shall not be construed to extend to any suit of law or equity commenced or prosecuted against one of the United States by a citizen of another state or citizens of subject or any foreign state. So if you are not a citizen of that state, you can't sue them in federal court. And even if you are a member of that state, you can't sue them in federal court unless a specific federal law applies. So how this comes up in this situation, we'll find out. The immunity extends to lawsuits brought by citizens against their own states. As a matter of interpretation, that's right. It doesn't say it on its own terms, but it does. This immunity extends to citizen suits brought by citizens against their own state. It does. That is not controversial, at least as far as the law goes. It also extends to suits against state agencies or departments. Yes, any instrumentality of the state government. Yes, correct. But not against local governments. Yes. State agencies or state departments, or another way to phrase that is instrumentalities of the state, not to be confused with local governments or county governments or anything other than state governments, to which the 11th Amendment does not apply. A suit against a state agency or its department or a state official is in fact a suit against the state. Yes, it is. It's an instrumentality of the state. It's the same thing as the state. And it's barred regardless of the nature of relief sought. Correct. The general rule is that a suit against the sovereign, if a judgment is sought, would expand itself on public treasury or domain, or interfere with the public administration, or the effect of the judgment would be restrain the government from acting or compel it to act. Fair enough. 11th Amendment immunity is subject to 3 exceptions. Congress abrogation, as I said, if there's a law from Congress that specifically abrogates it, you can do that. Waiver by the state. Yeah, if the state says you can sue us. So the state could, by its own state law, say you can sue us in federal court, which incidentally does happen. Yeah. And a suit against a state official seeking prospective injunctive relief to end a continuing violation of federal law. So if what we want is an injunction to prevent you from continuing to violate federal law, then we can do that. That's fine. Congress did not abrogate the state's sovereign immunity when it enacted 42 U.S.C. 1983. That's true. The state of Michigan has not consented to being sued in civil rights actions in the federal courts. Fair enough. The 11th Amendment therefore bars plaintiffs' claims against the Michigan Board of Canvassers, as the Board of Canvassers is a state agency. True. Plaintiff claims are also barred against Governor Whitner and the Secretary unless a third exception applies. The third exception applies from a decision called Ex parte Young. where if NATO is in the chat right now, I'm sure he's getting all the feels right now because he loves himself. He loves himself some ex parte Young. I love you, Nate. But as the Supreme Court has advised, to interpret Young to permit a federal court of action to proceed in every case where prospective declaratory and injunctive relief is sought against an officer, namely in his official capacity, would adhere to an empty formalism and undermine the principle that the 11th Amendment immunity represents a real limitation on federal court's federal court jurisdiction. The real interests served by the 11th Amendment are not to be sacrificed to elementary mechanics of caption and pleading. As is true in many things in law, we don't necessarily look to what is on the label. We look to what it is, right? You can call it anything you want. Buy a rose, but a rose by any other name would smell just as sweet. So yeah, we don't look to what it is on the label. We look to what it is. Application of the Young exception must reflect a proper understanding of the role in the federal system and respect for state courts instead of respective reliance or an obvious fiction. Here we mean legal fiction. So you can't just dress this up to get around this, because federal courts are limited because we live in a federated republic, and federal courts have limitations. Yeah. Further, the theory of Young has not been provided an expansive interpretation. True. In determining whether the doctrine of ex parte Young avoids the 11th Amendment's bar to suit, a court need only conduct a straightforward inquiry into whether the complaint alleges an ongoing violation of federal law and seeks to properly characterize it as prospective. That is forward-looking. That is what it means to be prospective. Ex parte Young, however, does not apply to state law claims against state officials, regardless of the relief sought. And a federal court's grant of relief against state officials on the basis of state law, right? States are in charge of their own state law. Whether prospective or reactive does not vindicate the supreme authority of federal law. No. Remember, one of the three things that we discussed was when you're looking for prospective relief, but for federal law. The federal courts do federal law. The state courts do state law. If you're in a federal court to try to get a state official to obey state law, you are in the wrong place, sir. You are in the wrong place, sir. No. States are in charge of their state law. Go yell at the state Supreme Court if you want. Get the hell out of my courtroom, says the federal court. Yeah. Federal courts are, in fact, limited. This entire thing, one of the nice things about this entire series of lawsuits, it has been maybe the best education of anything we've ever covered on federalism, right? Which, incidentally, I'd like to point out to the people who are critical of me for not being a good Republican or not being a good conservative, I'd like to point out that federalism and strong belief in federalism is normally considered to be a conservative value, right? Local level control, state level control, state rights. These are normally thought to be conservative values and conservative legal principles. And amazingly, I apply my conservative legal principles as best as I am able, regardless of who the figures are in power. Because I know full damn well that what will help me today will help me tomorrow, and what will hurt me today will hurt me tomorrow. And if I give something to the other side, I have to give that to me. And if I give it to me, I have to give it to the other side, right? So there's not like, but this one time, though. There's not really a but this one time, though. So I actually believe in concepts like there is a federal government and there are state governments, and these are separate and distinct things. And the state governments get to decide state issues, and the federal government get to decide federal issues, and they need to stay the hell away from each other. And a lot of people in these videos, or the response to the videos, seem to be very, very salty because they want the federal government and the federal courts to come and intervene in all the places. And I have to think to myself, have you really thought that all the way through, guys? I know the answer is no. It's like, do you really want the federal government and the federal courts to come in, and you really want them to start ordering the states around? It's like, yay, Trump is elected because of that. Well, guess what you just did? You just granted a massive encroachment to the federal government over state power. You know? So this is a do you believe in federalism? The game is now what this entire series of lawsuits are. Do you actually believe that there's a federal government? Do you actually believe there's a state government? Do you actually believe that they're separate and distinct? Do you actually believe the states should deal with state issues? Do you actually believe the federal government should deal with federal issues? Do you believe the federal government should stay the hell away from the states? Do you believe that or not? This entire thing has been, this thing has been a massive education on federalism, especially to our foreign friends in other countries overseas who are not familiar with these concepts or are less familiar with these concepts, because different countries have different relationships, to be sure, but there's not many countries that have relationships like ours. You don't normally think of like province level autonomy or district level autonomy in quite the same way. You certainly don't normally use a word like sovereignty. You don't normally think of like, if you're, whatever else you might consider it, you don't normally, like if you're in Germany, think about the sovereignty of localities. That's a little bit weird as a concept, whatever power they might have. And over here in the United States, we're suddenly talking about, hey, the United States government, the United States federal government doesn't actually have all the sovereignty, guys. It only has some of the sovereignty. The states have sovereignty too. And people get confused by this concept because it's a weird concept, but that's how we do it. It's how we roll in the United States. The federal government is sovereign. The states are sovereign. And we have been fighting over this for the last 250 years. The fight will never end. We had a really big fight over it in the 1860s. You might want to read about it sometime. All right. Anyways, a federal court grant of relief against state officials on the basis of state law, whether prospective or reactive, does not vindicate the supreme authority of the federal law. No. On the contrary, it's difficult to think of a greater institution of state sovereignty than when federal court instructs state officials on how to conform to, and this will be again the critical words of this sentence, so pay attention, to their state law. That's just a non-starter. Federal courts are not going to order a state government with respect to their own state law. That is just not a thing that is going to happen. No. If a plaintiff sues under a state official under a state law in federal court for actions taken within the scope of that authority, sovereign immunity, and also the principles of federalism, bar the lawsuit regardless of whether it seeks monetary or injunctive relief. Right. Unquestionably, plaintiff state law claims against defendant are barred by this 11th Amendment immunity. Yeah. The court then turns its attention to the 1983 claims. The defendant and the intervener contend these claims are not, in fact, federal claims, as they're premised entirely on alleged violations, and this would be, again, the key words, alleged violations of state law. State law. You can't bring a 1983 claim in federal court for a violation of state law. That's just a non-starter. Here, each count of the plaintiff's complaints, which claims to raise violations of federal law, is instead predicated on the election being contrary to Michigan law. We got to teach you guys about some federalism over here, man. We got to teach you about some federalism. You can't do this. While some of the plaintiff's allegations concern fantastical conspiracy theories that belong more appropriately in the fact-free reaches of the internet, nice burn. That's a nice little burn. That's from the legal filings. They're quoting the legal filing, but still, it's in the court opinion now. So they're quoting the attorney for the case and putting it in the court filings. So that's a nice little burn. While some of these concern fantastical conspiracies that belong more appropriately in the fact-free outer reaches of the internet, nice. What plaintiffs assert at bottom are violations of Michigan Election Code, otherwise known as Michigan state law. The Kraken is of ill health. Send help. The Kraken is of ill health. It's not going well. Defendants also argue that even if properly stated as federal causes of action, it's far from clear whether plaintiff's respective requested injunction is actually prospective in nature as opposed to reactive, which, it's probably not prospective. It's probably reactive, which is also not what Ex parte Young allows for. Also, it's not a federal cause of action. Yeah. Later argument convinces this court that Ex parte Young does not apply. As set forth earlier, in order to fall within the ex parte Young exception, a claim must be prospective, that would be forward-looking relief, to end a continuing violation of, and to say it again, because these are the key words of the sentence, so pay attention, federal law, federal law, federal law. We're in federal court, we need federal law. Federal law, federal court. State law, state court. Federal and state are in fact different words. Unlike in a prior case, which plaintiffs cite in the reply brief, this is not a case where plaintiff is seeking to enjoin the continuing enforcement of a statute that is allegedly unconstitutional, which would make it a violation of federal law, right? So they want to stop the state from enforcing a state law, but the state law in question is in conflict with federal law, which makes it a federal law issue. Right. Instead, plaintiffs are seeking to undo what's already occurred, as the request of relief reflects. Before the lawsuit was filed, the Michigan Board of State Canvassers had already certified the results, and the governor had transmitted the state's slate of electors to the United States Archivist, which, is something they're supposed to do, but I don't really think it has any formal thing in the problem. I mean, it's a thing you do because it's part of the official records of the United States. So the United States Archivist, in case you're wondering what the United States Archivist does, the United States Archivist keeps track of federal records. That's one of the things they do. Or they're also the people who have the Declaration of Independence and the Constitution. And you can go see and if you ever go to the National Archives in DC, and you can go see it in person, behind glass and shit. And if you ever want to see a movie about it, you can go see National Treasure. You can see a documentary about Nicolas Cage stealing the Declaration of Independence. Good times. So anyways, then the United States Archivist, among other things, he keeps federal records. And so because this has to deal ultimately with federal elections, right, the law says, please send the Archivist of the United States a copy so he can put it in the federal records. Yeah, okay. There's no continuing violation to enjoin. For these reasons, the 11th Amendment is a complete non-starter. The Kraken is not looking really well. This case represents well the phrase, the ship has sailed, so it's moot. The time has passed to provide most of the relief. For these matters, the matter is also moot. Under Article 3, the federal courts may adjudicate only actual, ongoing cases. A case becomes moot when the issues presented are no longer live or the parties lack a legally cognizable interest in the outcome. Stated differently, a case is moot when the court lacks the ability to give meaningful relief. This law was moot well before November the 25th. In their prayer for relief, the plaintiffs asked the court to order the defendants to decertify the results, enjoin the secretary and the governor from transmitting the results to the Electoral College, order the defendants to transmit certified results that the slate of President Donald Trump is the winner of the election. We're asking for a lot, aren't we? Impound all voting machines and software for expert inspection, order that no votes received or tabulated by machines not certified as required by federal or state law be counted, and enter declaratory relief. Well, we're certainly asking for a lot of things, aren't we? What relief this court could grant plaintiffs is no longer available. Before this lawsuit was filed, all 83 counties in Michigan have finished canvassing the results for all elections and reported the results to the state office for the Secretary of State and the Michigan Board of Canvassers. The board has certified the results and submitted the results before this lawsuit was ever filed. The time for requesting a special election based on mechanical errors or malfunction in voting machines has expired, and so is the time for requesting a recount for the office of the president. The Michigan Election Code sets forth detailed procedures for challenging an election, including deadlines. Plaintiffs did not avail themselves of the remedies set out for in the state law. The deadline for them to do so has passed. Any avenue for this court to provide meaningful relief has been foreclosed. As the 11th Circuit Court of Appeals has recently observed in one of the many other Kraken wannabe lawsuits, we cannot turn back the clock and create a world in which the 2020 election results are not certified. It is not possible for us to delay certification nor meaningfully order a new recount when the results are already final and certified. As one justice of the Supreme Court of the state of Pennsylvania advised in another 2020 lawsuit, there's no basis in law by which the courts may grant the request to ignore results of an election and recommit the choice to the General Assembly to substitute its preferred slate of electors to the one chosen. In short, the requested relief is moot. Laches, which is kind of an extension of mootness in this context. It's like it's already over, you waited too long. It's kind of one and the same, but whatever in this context. Defendants argue the plaintiffs are unlikely to succeed because they wait too long to knock on the court's door. The court agrees. The doctrine of laches is rooted in the principle that equity aids the vigilant, not those who slumber on their rights. An action may be barred by laches if the plaintiff delays unreasonably in asserting their rights and defendant is prejudiced by the delay. First, the plaintiff showed no diligence in asserting these claims. They filed the instant action on November the 25th, more than 21 days after the 2020 election, and served on the defendant some 5 days later. If plaintiff had legitimate claims regarding whether the treatment of election challenges complied with state law, they could have brought their claims well in advance of election day, but they did not. Michigan's 83 Board of Canvassers finished canvassing not later than the 17th, and on the 23rd, they certified. If plaintiffs had legitimate claims regarding the manner in which the ballots were processed and tabulated, they could have brought the instant action on election day or during the weeks of canvassing that followed, yet they did not. Plaintiffs based their claims relating to election machines and software on expert facts and witnesses reporting discussing glitches and other alleged vulnerabilities that occurred as far back as 2010. If plaintiffs had legitimate concerns about the election machines and software, they could have filed this lawsuit well before the 2020 election, yet they stood back and did nothing. Plaintiffs proffer no persuasive explanation for why they waited so long. Plaintiffs concede that they would have preferred to file sooner, but they need some time to gather statements from dozens of witnesses, retain and engage expert witnesses, and gather other data. But according to plaintiffs themselves, manipulation of the votes was apparently shortly after the polls closed. Well, you could have filed a lawsuit, and then you could have perfected it if you had to. Indeed, when there's no reasonable explanation, there can be no justification. Defendants satisfy the first element of laches. The plaintiff's delayed prejudices the defendant. This is especially so concerning the plaintiff's claim for relief are not merely last minute, they are after the fact. While plaintiffs delayed, the ballots were cast. The votes were counted, and the results were certified. The rationale for imposing the doctrine of laches is now at its peak. Plaintiffs could have lodged their constitutional challenges much sooner than they did, and certainly not 3 weeks after Election Day and 1 week after the certification. The court concludes that the laches, abstention doctrines, this is the one where NATO gets really, really happy is on the abstention doctrine stuff. So this part is for NATO 2000, where he gets to geek out over the abstention stuff. As outlined in several filings, when the present lawsuit was filed on the 25th, there are already multiple lawsuits pending in Michigan state courts relating to the same claims. Defendant and the City of Detroit ordered the court to abstain from deciding these claims in deference to those lawsuits. Defendants rely on abstention doctrines outlined by the Supreme Court in Colorado River Water Conservation District v. United States. The City of Detroit relies on abstention doctrines outlined in Colorado River, as well as those set forth in Railroad Commissioner versus Pullman and Burford versus Sunwell. The City of Detroit maintains abstention is particularly appropriate when resolving election disputes in light of autonomy provided to state courts to settle these disputes. The abstention doctrines identified in Colorado River permit a federal court to abstain from exercising jurisdiction over matter in deference to a parallel state court proceeding. We could do this, we're just not gonna. We could do this, we're just not gonna. The state courts got this one. They're good. This is dealing with state elections and state stuff. We could, we're just not going to. Abstention. These doctrines are well understood in federal law. They are relatively rare, all things being considered, so you don't hear a lot about them. They don't come up very much, but they do exist, and this would be one of the times that they get invoked. So it's an unusual thing in the grand scheme of litigation. It's not a surprising thing, and it's not surprising it's here. It's like, yeah, abstention, easy. In this, easy. The exception is found warranted by considerations of proper constitutional adjudication, regard for federal state governments, federalism, or wise judicial administration. The Sixth Circuit has identified two prerequisites for abstention. First, the court must determine that concurrent state and federal actions are parallel. Second, the court must consider the factors outlined by the Supreme Court, whether the state court has assumed jurisdiction, where the federal form is less convenient, the avoidance of piecemeal litigation, the order in which jurisdiction was obtained, where the source of governing law is state or federal. That's going to be pretty key. The adequacy of state court action to protect the federal rights, the relative progress of the state and federal proceedings, and the presence and absence of concurrent jurisdiction. These factors, however, do not comprise a mechanical checklist. Correct. Rather, they require a balancing check. Fair. As summarized in the response and reflected in their exhibits, the allegations and claims in the state court proceedings and pending matter are at the very least substantially similar. A careful balancing of the factors in favor of deferring to the concurrent jurisdiction of the state court. State courts can deal with this. They got the ball. It is state law issues. It's state board canvassers. It's state precincts. It's state machines. It's the state legislature. It's the state election code. You know, state courts got this. They're good. No problem. Go yell at them for a while. The first and second factor weigh against abstention. While the Supreme Court has stated the presence of federal law issues must always be consideration in weighing against surrendering jurisdiction, this factor has less significance where the jurisdiction to enforce statutory rights in question is concurrent with that of the state courts. The Michigan Election Code seems to dominate even plaintiffs' federal claims. So while the Supreme Court has said we must be wary of giving up when there are federal law issues, there's not really federal law issues. They pretend there are federal law issues. They try to dress them up as federal law issues, but they're not really federal law issues. These are really state law issues. So while the Supreme Court has said, you probably shouldn't give up jurisdiction in federal causes of action, despite what they put on the label, this is not really a federal cause of action. Which is not. The Michigan governor and the Michigan Secretary of State and the Michigan Board of Canvassers and the Michigan County precincts and the Michigan voting machines and the Michigan election law. This sounds suspiciously like issues from Michigan. Piecemeal litigation occurs when different courts adjudicate the identical issues, thereby duplicating effort and potentially rendering conflicting results. The parallel proceedings are premised on similar factual allegations. The state court proceedings were filed well before the present matter, and at least 3 of those are more advanced. Lastly, as Congress conferred concurrent jurisdiction on state courts to do 1983. For this reason, no. Just no. Go yell at the state courts about all the Michigan issues if you want. Let us know how it works out, except don't. We don't really care. Under Article 3 of the Constitution, federal courts can resolve only cases in controversy. The case or controversy is satisfied only when a plaintiff has standing to bring suit. Each plaintiff must demonstrate standing. To demonstrate standing, a plaintiff must show you have suffered an injury that is concrete and particularized and actual or imminent. It must affect you in particular, and it must have happened or be about to happen. The injury is traceable to what the defendants did. The defendants are responsible. And it's likely the injury will be redressed. Okay. Let's deal with equal protection and destroy the equal protection arguments. So now we get into, let us completely destroy your federal constitutional arguments. Because they're all crap. This is the let's destroy your federal constitutional arguments because they're all crap hour. The chat, not only my chat, but everyone's chat on this has been like, every election dealing with the federal government is federal. This is presidential. That means the court of jurisdiction. There's equal protection. There's the election clause. Okay, so the court is about to explain in small, easy to understand words why no. Just no. So let's explain in small, easy to understand words. Let's deal with equal protection. Plaintiffs allege defendants engage in several schemes to destroy, discard, or switch votes, thereby devaluing Republican votes and diluting the vote. Plaintiffs' contention that vote dilution results from the systemic and illegal conduct did not affect all Michigan voters equally, and that the intent and effect of inflating the number of votes of Democratic candidates and reducing the number of votes for Republican candidates. Even assuming the plaintiffs established injury in fact and causation under this theory, their claim cannot stand because plaintiffs fall flat when attempting to clear the hurdle of redressability. It's non-redressable. It's non-judiciable. Plaintiffs fail to establish the alleged injury of vote delusion can be redressed by this court. Plaintiffs ask this court to decertify the vote, but in order to decertify, approximately 2.8 million people would not reverse the dilution of the vote. That's true. To be sure, standing is not dispensed in gross. A plaintiff remedy must be tailored to that plaintiff. Plaintiff's alleged injury does not entitle them to seek the requested remedy because the harm of having one's vote invalidated or diluted is not remedied by denying others their right to vote. Accordingly, plaintiffs have failed to show their injury can be redressed by relief, and they have no standing to pursue equal protection. The Election Clause. The Elections Clause. Everyone's favorite clause as of late on the internet. Everyone loves the Election Clause suddenly. It's all the talk around the legal water coolers. The provision of the United States Code, the provision of the United States Constitution, known as the Elections Clause, states in part, the time, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. The Election Clause effectively gives state government default authority to regulate the mechanics of federal elections, with Congress retaining exclusive control to make or alter those regulations. The Election Clause of the Constitution states, each state shall appoint in such manner as the legislature thereof may direct a number of electors. Plaintiffs argue that as nominees of the Republican Party to the presidential electors on behalf of the state of Michigan, they have standing to allege violations of the Election Clause and Electors Clause because a vote for Donald Trump and Vice President Pence is a vote for each Republican elector, and illegal conduct aimed at harming candidates for a president similarly injures the electors. But whereas here, the only injury they have alleged is from the Election Clause not being followed, the Supreme Court of the United States has made clear this injury is precisely the kind of undifferentiated, generalized grievance about the conduct of government that courts have refused to deal with. Because they have no asserted particularized stake, the plaintiffs fail to establish injury in fact, and thus standing to bring their Election Clause. Easy. Done. This is so because the Election Clause grants rights to the legislature of each state. The Supreme Court interprets the word the legislature as used in that clause to mean the lawmaking bodies of the state. The Election Clause therefore grants the right to state legislatures and other entities to which the state may delegate lawmaking authority. Plaintiff's Election Clause therefore belongs, if anyone, to the Michigan State Legislature. Plaintiffs here are 6 presidential electoral nominees. They are not part of the Michigan lawmaking bodies, nor do they have a relationship with them. To support their contention they have standing, plaintiffs point to Carson, a decision finding electors had standing to bring challenges under the Election Clause. In that case, which was based on specific content and contours of Minnesota state law, the 8th Circuit Court of Appeals concluded that because the plain text of Minnesota law treats prospective electors as candidates, it too would treat presidential elector nominees as candidates. So the way Michigan wrote its law, the electors themselves are candidates for office, to the office of elector. That's the way Michigan wrote its law. This court, however, is unconvinced about the majority holding. So a different court has disagreed. And it cites for dissent. And here there's a cite from Carson. So this is instituting Minnesota law, which is a different state than Michigan, as Sidney Powell learned recently when citing voting numbers. Michigan is in fact a different state from Minnesota. So in Minnesota, they said this is true. And now a Michigan court is trying to figure out what is true in Michigan. And now they're going to cite the dissent because they find it more persuasive because it's a different state. Wow. I'm not convinced electors have Article 3 standing to assert claims. Although Minnesota law at times refers to them as candidates, the electors are not candidates for public office, as that term is commonly understood. Whether they ultimately assume the office of elector depends entirely on the outcome of the state vote of president. They are not presented to and chosen by the voting public of office, but instead automatically assume office based on public selection. The plaintiffs contend that the Michigan Code and relevant Minnesota law are similar. Even if this court were to agree, it finds lack of standing. Yeah, it's not going great. So the court may deny motion for injunctive relief for reasons. Nevertheless, the court will proceed to the merits. So this is fun. So now, having told you in 8 different ways the court doesn't want to hear your case, having told you 8 different ways the court doesn't want to hear your case, the court is not going to hear your case anyway, just to further beat up on you. So having told you 8 different ways the court doesn't want to hear your case, I'm now going to hear your case just to further rub in the dagger. Yeah. Plaintiffs allege defendants violate the election clause and electors clause by deviating from the requirements of Michigan's election code. Even assuming defendants did not follow the Michigan election code, plaintiffs do not explain how or why such violations of state election procedures automatically amount to violations of the clauses. In other words, it appears that these are state law claims dressed up as federal claims. A review of Supreme Court cases interpreting these clauses supports this conclusion. In a case called Cook, the Supreme Court struck down a Missouri state law that required election officials to print warnings on the ballot next to the name of any congressional candidate who refused to support term limits, after concluding such a statute constituted a regulation of congressional election as used in the election clause. In Arizona state legislature, the Supreme Court upheld an Arizona law that transferred redistricting power from state legislature to an independent commission after concluding that the legislature, as used in the election clause, indicates any official body within the authority to make laws for the state. In each of these cases, federal court measured the enacted state law against federal mandates established in the clauses. They did not measure violations of state law against federal law. By asking this court to find they have made out claims under the clauses due to alleged violations, plaintiffs asked this court to find any alleged deviation from the state law amounts to a modification of state law and opens the door for federal review. No. If they violated state law, that's super interesting and all. And even if that means they modified state law, that's a state law issue. Go tell a state court about it. They'd love to hear all about it. Plaintiffs support no case, cite no case, and we can find none supporting such an expansive approach. Yeah, no. Most election laws will impose some burden on individual voters, but our Constitution leaves no room for classification of people in a way that unnecessarily abridges the right to vote. Voting rights can be impermissibly burdened by a debasement or dilution of the weight of a citizen's vote just as effectively as prohibiting the exercise. Plaintiffs attempt to establish equal protection based on the theory that they've established schemes to destroy, discard, and switch votes that dilute the vote. But to be perfectly clear, plaintiffs' equal protection claim is not supported by any allegation. Defendants' alleged schemes cause votes for President Trump to be changed to votes for Biden. For example, the closest they get to alleging any physical ballots were altered in such a way is the following statement in an election challenge in a sworn affidavit. I believe some of those workers were changing votes that had been cast for Donald Trump and other Republican candidates. But of course, a belief is not evidence and falls far short of what might be required to obtain relief, much less the extraordinary relief that the plaintiff requires. The closest the plaintiffs get to alleging that the election machines and software changed votes for President Trump to Vice President Biden in Wayne County is an amalgamation of theories, conjecture, and speculation that the alterations were possible. And plaintiffs do not explain at all the question of how the treatment of election challenges comply with state laws bears on the validity of votes or otherwise establishes equal protection under federal law. With nothing but speculation and conjecture, which are kinds of evidence that voters for President Trump were destroyed, discarded, or switched, plaintiff equal protection fails. Because of finding that there's no likelihood on the merits is usually fatal, the court will not discuss the remaining factors extensively. As discussed, plaintiffs failed to show a favorable decision would address their injury. Moreover, granting the injunctive relief would harm the public interest. As defendants aptly described, plaintiffs' requested injunction would upend the statutory process for election certification and the selection of electors. Moreover, it would disenfranchise millions of voters in favor of the preferences of a handful of people who are disappointed with the results. In short, none of the factors grant relief. Conclusion. For the following reasons, the court finds the plaintiffs are far from likely to succeed. In this fact, this lawsuit ceases to be less about achieving the relief, as much as that relief is beyond the power of the court, and more about the impact of the allegation of people's faith in democratic processes and the trust of government. Plaintiff asks this court to ignore ordinary statutory schemes established to challenge elections and ignore the will of the voters. This the court cannot and will not do. The people have spoken, therefore go to hell. Yeah, so that's the end of that. So, yeah, that brings us to the end of that brings us to the end of the discussion of the Michigan Kraken in the case of various people versus various other people. So yeah, in this case, we learned that the Kraken might be a mere guppy, and the guppy is less than impressive. So the Kraken was less than it turned out to be, and the court has to explain in the court has to explain in a 36-page opinion. So if you're looking for the principal takeaway from this case, what I would say the principal takeaway from this case is that state law issues are state law, and federal law issues are federal law. And just because you say it's a federal law issue does not make it a federal law issue. When you're saying the Michigan Board of Elections certified a bad result as a result of the canvassing of the Michigan county level elections, as a result of the Michigan voting machines and the Michigan voters, and the Michigan Secretary of State and the Michigan governor and the Michigan board are violating the Michigan election law. The word Michigan comes up quite a lot. It kind of tells you the answer to the question of go complain to a state court about it. Maybe they'll be interested. And just because you say this is an equal protection clause, and just because you say it's an election clause, and just because you say other things, it's like, no. You know, what you put on the label is super interesting and all, but it sounds suspiciously like you're upset with the Michigan law. So go complain to a Michigan court about it. And why are you here in federal court? And also, your relief is decertify. Your complaint is our votes were diluted, and your requested remedy is throw out all the votes. So you want your vote to be honored by throwing out. You want your vote to be honored in the place it should be honored by throwing out all the votes. How does that give you what you asked for? How does making sure that your vote truly counts? I want my vote truly to count. Therefore, throw out all the votes. That doesn't really work. And also, it's a massive remedy, and I believe this might have happened. It's possible it could have happened. Here's some conjecture that it could have happened. Does not a lawsuit make? So, yeah. I'm kind of looking forward at this point to all these lawsuits being over so I can stop talking about this, because this is, this is all like, yeah. So, thank you, Cindy Powell and all, but no. Just no. Well, there being no super chats today, I will simply end the stream. If you like the stream, please make sure to subscribe. It really helps the channel grow. I hope today I have earned your subscription, and you can always unsubscribe later. So I hope today I have earned your subscription, and you'll be so kind as to subscribe to help the channel grow. Until later, my friends, cheers and goodbye.